not read this yet, so I wanted to read it to you guys, and then we'll just read it together. And if you guys haven't read it yet either, don't worry, I'm here. I'll read it to you. Who wants to read this stuff anyways? Unlike your, what is it called? Not the Kindle. What's the other one that reads things to you? Audible. I'll be your Audible. But yeah, look at this. This is some fancy stuff right here. Virginia Court of Appeals, Amber Heard. So this is a brief of appellant. All right, we got all the lawyers listed there. I love how they have table of contents too. So neat and nicely organized. Oh, the cases they refer to. Gotta have your citations and statutes, rules, and other stuff. Okay, cool. Let me see. How is this font okay? I'll move to the side a little bit. All right. This appeal arises from a 6-week jury trial on competing claims for defamation. Appellant John C. Depp II, Mr. Depp, alleged that the appellee, Amber Laura Heard, Ms. Heard, defamed him by implying in an op-ed in the Washington Post, the op-ed, that he had her during their relationship and brief marriage. By counterclaim, looks good? All right, wonderful. By counterclaim, Ms. Heard alleged that one of Mr. Depp's attorneys, non-party, Adam R. Waldman, Mr. Waldman, defamed her in 3 statements, collectively the Waldman statements, to the UK tabloid The Daily Mail, claiming that Ms. Heard's claims of abuse were false. She alleged that Mr. Depp was vicariously liable for his attorney's statements. Mr. Depp filed a motion for summary judgment on a single counterclaim. On March 24th, 2022, the trial court denied Mr. Depp's motion. The case was tried from April 11, 2022 through May 27, 2022. On May 21st, at the end of Ms. Heard's case, Mr. Depp made a motion to strike her claims, which was denied, and Mr. Depp renewed such motion on May 26, 2022, which was also denied. On May 27, the jury retired to deliberate. On June 1st, it returned its verdict, which overwhelmingly favored Mr. Depp. The jury found that Ms. Heard defamed Mr. Depp in op-ed and awarded Mr. Depp $10 million in compensatory and $5 million in punitive damages. On the counterclaim, the jury found in Mr. Depp's favor on 2 of 3 Waldman statements, but in favor of Ms. Heard on the 3rd Waldman statement. That is the only statement at issue in this appeal. Oh man, wouldn't it be so funny if both sides appealed and then Amber completely lost her appeal, but then like they gave Johnny like his appeal, so like that way she has to owe him even more money. I don't know, that would just be hilarious. On June 24th, 2022, the trial court entered judgment on the jury's verdict. Mr. Depp timely noted his appeal on July 22nd. The jury's emphatic favorable verdict on all 3 defamatory statements alleged in his complaint fully vindicated Mr. Depp and restored his reputation. Indeed, Mr. Depp prevailed in the trial court on virtually all material issues, and the verdict of the jury and the judgment of the trial court represented an intelligent and well-reasoned decision on the merits after full and fair trial and should be largely, though not entirely, affirmed. However, the trial court was confronted with a number of novel and complex legal and factual issues, and although the trial court decided the vast majority of those issues sensibly and correctly, a few rulings were erroneous. Mr. Depp does not appeal the verdict on his claim, nor does he appeal the verdict in his favor on 2 of the 3 Waldman statements. His appeal relates solely to the Waldman statement on which Ms. Heard prevailed, a statement in the Daily Mail article dated April 27. The judgment in Ms. Heard's favor on that lone statement is erroneous. Ms. Heard's claim was fatally flawed, and the trial court should have granted Mr. Depp's motion for summary judgment and his motion to strike the evidence for 3 reasons. First, Mr. Depp cannot be held liable for Mr. Waldman's statements as a matter of law. I do have a question, though, because after the verdict came out, didn't Adam Waldman, leak something? It was, an email that he wrote to Camille saying that, what's his name? Josh Drew confirmed that the thing was a hoax, the spilling a little bit of wine, messing up the apartment and stuff like that. Isn't that what Adam Waldman was basing his statement on? So I wonder how come that was precluded from the trial. Was it too much hearsay, and then maybe Josh Drew decided to withdraw from making that statement or something like that? That's what I want to know. I want to know why. Hey Brandon, how are you doing today? How's it going? Should just keep pledging the monies. Ms. Heard's, oh shit, we're over here now. First, Mr. Depp cannot be held liable for Waldman's statements as a matter of law. Ms. Heard sought to hold Mr. Depp. Oh, by the way, if you guys have that email that I was referencing, I don't have the email link. If you guys do, like, can you link it in the chat? But there was an email that Waldman wrote to Camille Vasquez about Josh Drew. Ms. Heard sought to hold Mr. Depp liable for April 27 Waldman's statement on pure theory of vicarious liability, contending that Mr. Depp was liable merely because Mr. Waldman had been retained by Mr. Depp as his attorney and was therefore his agent. But as a matter of law, Mr. Waldman is an independent contractor whose allegedly tortious conduct is not automatically attributable to Mr. Depp. Indeed, a wealth of authority support limiting a client's liability for allegedly tortious conduct by an attorney, and the court should impose that same limit here. Because I think the point that Ben Roddenborn was making was that I think he said that, like, oh, when you were doing the interview with Daily Mail, well, wasn't Johnny Depp there or something like that? Or like, weren't you meeting with Johnny Depp before? It was something like that. I like vaguely remember that during the trial when Ben Roddenborn was questioning Johnny Depp. Or was he questioning Adam Waldman? It's just a vague memory. Does anyone here remember that by any chance? It would have been hearsay. Yeah, because like, they had Josh Drew testify. So maybe he told Adam Waldman that. And then like Josh Drew was like, oh shit, maybe I should have said that. And he like retracted it or something like that. Second, because Ms. Heard proceeded against Mr. Depp at trial on a purely vicarious theory of liability, she was required to present evidence that Mr. Waldman committed each element of the tort of defamation, including that he acted with actual malice. No evidence of Mr. Waldman's actual malice was presented at trial, so the judgment against Mr. Depp cannot be sustained. I mean, because we see that in movies a lot, right? Where like you have a victim who's like, or a witness, who's like willing to come forward. They tell the police like, oh, this is what happened, XYZ, and then all of a sudden, like, they decide to not go forward through the trial, right? So I wonder if that's what happened with Josh Drew. Like, was he being forthcoming and was being honest? And then when it actually came to like the trial happening, he was like, oh shit, never mind. I take back my statement. Never mind. No. Third, the April 27 Waldman statement viewed in context is a non-actionable statement of opinion insufficient to support a claim for defamation. In addition to erroneously denying Mr. Depp's motion for summary judgment and motion to strike, the trial court also erred in 1. Excluding from evidence of the complete Daily Mail articles containing the Adam Waldman statements. 2. Refusing to give jury instructions as to Mr. Waldman's status as an independent contractor. Ooh, yeah, because I remember Judge Penny was like, nah, he's not considered an independent contractor. He's considered the lawyer. I think I remember because like they tried to get it dismissed so many times, like I think once or twice. Assignments of error. The trial court erred by denying Mr. Depp's motion for summary judgment as to Ms. Heard's counterclaim, and 2, Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. Or maybe Judge Penny says that it's up to the jury to make that decision. Ooh. A. Mr. Waldman is an independent contractor. Mr. Depp is not liable for Mr. Waldman's allegedly tortious conduct as a matter of law. B. Ms. Heard failed to present any clear, convincing evidence that the Waldman made the counterclaim statements with actual malice. The Waldman statements are not actionable statements sufficient to support a claim for defamation. All right. I could skip this a little bit. 2, the trial court erred in refusing Mr. Depp's postponed jury instruction numbers 22, 23, 24 as to whether Mr. Waldman was acting as an independent contractor when he made the Waldman statements. Do I still have the jury instruction? I don't think I have it saved on my computer. I might have deleted all the Depp Heard stuff when the trial ended. 3, the trial court erred in excluding the evidence, the full unredacted version of Mr. Depp's exhibit numbers 881A, B, and C, which are copies of news articles in which the Waldman statements appeared. Yeah, that's right, because like they didn't show the complete article. They only show like the excerpt. All right, statement of facts. Waldman hates Amber. According to the umbrella guy, he especially flew to Australia to help with him with the whole dog case. What? Amber? Wait, what? Adam Waldman flew to Australia to help with the whole dog case thing? Oh my gosh, dude. The whole dog case thing is like, it's pretty fucking wild. Like, I know, like, I don't know. I know there's other things that like gain more attention, but the whole dog thing was like wild to me. Like, Amber's ex-assistant had a lot of things to say about Amber that was just like, I don't know. To me, it was like really fucking mind blowing because this is when I didn't really like know who Amber Heard was. But goddamn, like her assistant testifying, woo, it hurt her so much. Anyways, yeah. Yeah, actually, you know what? Has anyone been hearing any updates about the Australia case? I feel like we were hearing some updates about the Australia case for a little bit after the trial was over, but now it's like quiet again. Like, what's going on with the Australia case? Like, are they gonna do something or not, or just like it's just in the ether right now? The first Waldman statement was quoted in Daily Mail article dated April 8, 2020, stated Ms. Heard had used fake sexual violence allegations and promoted sexual violence hoax facts. The article also contained a general discussion of dispute and litigation between Mr. Depp and Ms. Heard and quotes from attorneys adverse to Mr. Depp. The jury did not find this statement to be defamatory. Oh, also, if you guys could ever dig up, I think it's on like, I forgot what's the name of the website, but there's a website that has old screenshots of Adam Waldman's like tweets. Yo, his tweets are fire. Okay, they need to unban Adam Waldman. The second Waldman statement was quoted in June 24, 2020, Daily Mail article, and stated that Ms. Heard's allegations were a hoax. The article also included a quote from Ms. Heard's attorneys that believe Amber and we believe in Amber, and a summary of both Mr. Depp's and Ms. Heard's side of the dispute. The jury did not find the statement to be defamatory either. The April 27 Waldman statement, the sole statement on which the jury found in Ms. Heard's favor, is contained in the Daily Mail article. Oh my God, I'm just surrounded by dogs that are barking right now. It's driving me nuts. Holy shit. Hello, driver's seat. How are you doing today? Why has the public been so understanding to Johnny and Amber, two very troubled people? Let's be honest, Johnny has had his fair of issues. He attracted someone that is as jacked up he is, all the drinking, the drugs, drinking poop, and the weird behavior. I mean, so here's the thing. There's a difference between someone who has, like, an issue with, like, drugs, right? Versus someone who's gonna, out of nowhere, make, like, false allegations about another person and then destroy his livelihood. And he has kids, family, and all that stuff. Like, Johnny Depp is not perfect, and we shouldn't expect anyone to really be perfect, right? But to actually have the galls to just make fake allegations about someone and make up horrendous lies about someone, and especially as a public figure, that takes a very special type of person, I would say. All right, the April 27 Waldman statement, the sole statement on which the jury found in Ms. Heard's favor, is contained in a Daily Mail article dated April 27, 2020, with the headline exclusive, I need to report an A word. Listen to the 911 call listen to the 911 call made the night Johnny Depp and Amber Heard had a blowout fight that ended their toxic 18-month marriage, but both claim tapes back up their version of events. The April 27 article describes a recording of a phone call to the police on the night of April 21st, 2016, a date on which Ms. Heard alleged Mr. Depp threw a phone at her and roughed up the apartment at the Eastern Columbia building. The April 27 article comments that Heard's attorney says phone records and police department logs vindicate Heard's account for the final shocking episode of domestic DV she endured before filing for divorce, whereas Depp's legal team say this recording does the precise opposite. However, by raising discrepancies in the various accounts Heard and her allies have given on the notorious dust-up. It details Ms. Heard's various allegations about the abuse she claims to have suffered on May 21st, 2016. I think Johnny relapse was influenced by Amber's crazy personality. I mean, if we remember correctly, even Amber Heard said in her testimony, right, that when she met Johnny Depp, he was like, oh, I'm not drinking, you know, and he was drinking like lots of tea. I don't know if you guys remember her statement. So it's possible that because of the trauma that he endured with his mom, it's possible that because, like, you know, Amber Heard was also probably someone that was similar to his mom and it reminded him of his abusive mom, that's why he could have relapsed. But yeah, these are just, you know, conjectures. We don't really know for sure, but I'm just trying to remember what he said on his, because I don't think he really said that directly when he was on the witness stand, but I know that, like, when he was talking about his abusive mother, it was obviously a connection to, like, you know, the abuse that he endured with, like, Amber Heard. Details Ms. Heard's various allegations about the A she claims to have suffered on May 21st, noting that the DV case ultimately fizzled when the two LAPD officers who responded to the 8:27 p.m. call, Melissa Science and Tyler Haddon, said they never found any evidence of the crime. The April 27 article further states that Depp's lawyer, Adam Waldman, said in the various discrepancies proved that nothing Heard and her friends said about the events of May 21st, 2016 could be considered credible. I think he relapsed himself to dumb himself down to his young wife and her friends, but it cost him a lot. He could have died. Corgi, are you familiar with the second 911 call recording that Incredibly Average had on his channel? It sounds exactly like Rocky's voice. I did watch that. Didn't that video come out like 2 years ago or something like that? 2 or 3 years ago? I watched it, like, I think after the trial was over. And so that 911 call was very sus as well, because they said that, so the first call was made by Io, And they said the second call was made by a friend who wanted to stay anonymous but was in the same building. But the person that they claimed to have made that call, she was actually somewhere else at like a movie night watching like Silence of the Lambs or something. And people were like, oh, it actually sounds like Rocky's voice. So that's why people think that the May 21st was like a complete setup. Because when I first looked at this, the whole UK trial stuff, right? I thought the two events that was the most convincing, although it wasn't very convincing, but it was the most convincing out of all the shit that they, conjured. It was the May 21st phone throwing thing, and it was the night that she went on like the James Corden show, okay? But then I found out that there was footage of her on the James Corden show, and we got to see her face. We didn't see the black eye, we didn't see the split lip or anything. And then also the May 21st where a couple days afterwards, the bruise was gone and some other shit. Like, those were the two that I thought sounded the most convincing until more evidence came out. And it was just like, oh, okay, never mind. So, yeah, I saw that on Incredibly Average's channel. Yes. All right. These dogs are driving me nuts. Document. We're almost done. We're almost there. Look at that. Almost there. Oh, and you know what really sealed it for me? There are many like points of like, there are many points where it was just like, holy fucking shit, this bitch is lying. And one of the early points was when the police officer testified on the UK trial. It was, I think it was Melissa Sands and Tyler Haddon. I think they both testified for the UK trial. They're like, yeah, we didn't see any bruises. Like, we didn't really see anything. The apartment seemed fine. And I was like, oh no. Oh man. But anyways, let's get back into this. It details Ms. Heard's various allegations about the A she claims to have suffered, noting that the DV violence case fizzled when the two LAPD officers who responded to the 8:27 p.m. call, Melissa Sines and Tyler Haddon. And not only did we have one set of police officers, we had two sets of police officers that went to the apartment. Said they never found any evidence of the crime. Ooh! The April 27 article further states that Depp's lawyer, Adam Waldman, said the various discrepancies proved that nothing Heard and her friends said about the events of May 21st, 2016 could have considered credible. It sets up Mr. Waldman's reportedly defamatory statement. So this is the statement that they found to be defamatory. I don't feel like reading it. Should I read it? I'll read it. Okay. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops. The first attempt didn't do the trick. The officers came to the penthouse, thoroughly searched, interviewed, left after seeing no damage to the face of the property. So Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of the lawyer and publicist, and then placed a second 911 call. The April 27 article also includes quotes from Mr. Waldman that Ms. Heard did not include in her defamation claim. But even this didn't even have the desired effect because the two domestic A-trained LAPD officers would later provide a pair of sworn depositions saying they saw no evidence of a crime. These lies about who made the calls and when they are just on the tip of the iceberg, as the evidence will show in the court. Also, another thing too was that when I started realizing that the only people that were backing Amber's side of the story were only her friends and not anyone else outside of her like sphere of influence, that's when things start getting a little bit very rocky for her, because Johnny Depp had not only like his friends and employees on his side, it was other people that was on his side as well. But for Amber Heard, it was just all of her witnesses for the UK trial, they were all her friends. All right, finally presents a contrary view, quoting Ms. Heard's attorney at the time. Heard's legal team rejected those allegations as fantasies. Mr. Depp's representations about the 911 calls on the night of the May 21st are false, and Mr. Depp and his lawyers should know better, said her attorney, Roberta Kaplan, who is not her attorney anymore. After the evidence, including sworn testimony from multiple witnesses, phone calls, police department logs, are consistent with the truthful account given by a witness favorable to Ms. Heard. B. Evidence relating to the Waldman statements at trial. Ms. Heard presented no evidence at trial that Mr. Depp was personally involved in directing or making any of the three Waldman statements. Indeed, Mr. Depp testified that he had never seen the Waldman statements prior to the filing of the counterclaim in August of 2020. Mr. Waldman has a professional license, is the owner and managing member of his own law firm, and provides legal services to his client. Mr. Waldman was retained by Mr. Depp in October 2016 and still represented Mr. Depp at the time of the trial testimony. But Mr. Depp is not his only client. Mr. Waldman's relationship with Mr. Depp is solely one of attorney-client, and he has represented Mr. Depp in various litigation matters, including litigation against Ms. Heard. Mr. Waldman testified that while he believed, forgot to mute my music again, while he believed he had some knowledge of the conduct of Mr. Depp and Ms. Heard, he never personally witnessed any interactions between them prior to the retention of October 2016, which was after their separation. Mr. Waldman testified that he made each of the Waldman statements. Ms. Heard did not present any evidence on whether or why Mr. Waldman believed each of the specific statements. In response to a more general inquiry about Ms. Heard's allegations, however, Mr. Waldman testified at length on why he believed that Ms. Heard's allegations against Mr. Depp were false, describing physical evidence and identifying multiple witnesses whose testimony he believed contradicted her allegations. Mr. Waldman also testified that he had filed a claim with Los Angeles Police Department against Ms. Heard for perjury due to her claims that Mr. Depp abused her, and that he presented them with information that established her perjury. Argument. The trial court erred in denying Mr. Depp's motion for summary judgment and motion to strike the evidence. Standard of review. In reviewing a ruling on a motion for summary judgment or motion to strike, the court normally considers the relevant portions of a record in the light most favorable to the non-moving party and draws reasonable inferences in favor of the non-moving party. Citation, However, an appellate court in Virginia on the issue of punitive damages or where actual malice must be proven must independently decide whether the evidence in the record on appeal is sufficient to support a finding of New York Times actual malice by clear and convincing proof. Some citations. In addition, questions of law are subject to de novo review. Turner v. Kaplan, whether an allegedly defamatory statement is a actionable statement of fact or non-actionable opinion is a matter of law to be determined by the court and is reviewed de novo. Jordan v. Coleman. Under most circumstances, whether a person is an employee or an independent contractor is generally a question of fact for the jury. But whereas here the evidence admits only one conclusion, the question is a matter of law. That is reviewed de novo. Discussion. A. Mr. Waldman, independent contractor. Ms. Heard presented no evidence at trial. Mr. Depp was personally involved in directing or making the Waldman statement. So I think we're going to go into a little bit more into detail into each of the reasonings. Instead, she chose to pursue a pure vicarious liability claim against Mr. Depp, contending he was liable for Mr. Waldman's allegedly defamatory statements simply because Mr. Waldman was his attorney. Ms. Heard's proposed jury instruction on her counterclaim, which a trial court adopted and gave to the jury, were based solely on a vicarious liability theory and did not require a finding of any conduct by Mr. Depp in connection with the Waldman statement. That claim fails on a threshold issue, whether, as a matter of law, Mr. Depp can be held liable for the intentional tort of defamation based solely on a statement made by his attorney on a pure agency theory. When I hear Amber finally goes to jail, gets incarcerated, I will have a party here with my cat. It will be revolutionary. I mean, you can grow your arms back overnight, fix a nose in a broken day. Amica's the answer. In the context of vicarious liability, you know what? Next time I get a bruise, I'm going to get some Amica cream. Let's see if it actually works. Virginia has long recognized the distinction between servants and independent contractors and follows the well-established rule that a principal is generally not liable for the tortious claim or conduct, of an independent contractor. Recognizing in Virginia the doctrine of respondent superior imposes tort liability on an employer for the negligent acts of his employees, i.e. its servants, but not for the negligent act of an independent contractor, and declining to adopt an exception to this rule for the tortious claim of an independent contractor who was an ostensible or apparent agent. The theory in which the master is held liable for his servant's conduct is based on the right of the master, actual or potential, to control that conduct and to see the negligent acts which cause injury to others does not occur. Griffith v. Electrolux Corp. If the relation between them does not give the employer that power, then he should not be held responsible for an occurrence over which he had no control. In assessing whether the person is an independent contractor, courts consider 4 factors. 1. Selection and engagement. 2. Payment of compensation. 3. Power of dismissal. 4. Power to control the work of the individual. McDonald to blah, blah, blah. The 4th factor, the power to control, is determinative. Mr. Depp has not been able to identify any Virginia Supreme Court authority squarely considering the specific issues of 1. Whether the attorney retained in connection with litigation is an independent contractor. 2. Whether the principle limiting liability for conduct of an independent contractor applies in a principal-agent context, specifically with respect to the attorney-client relationship. Notably, the Virginia Supreme Court has cited with apparent approval the restatements approach, which limits liability of a principal for the actions of a non-serving agent. Wait, why am I not wearing my glasses? Let me wear my fucking glasses. Oh, much better. Everything is so clear now. The real thing's called Arnica. Oh, yeah, I know it's called Arnica cream. We think that the R and the N was probably like close to each other, and then Elaine's thought it was an M. So, honest mistake, but still funny that it happened. Although other jurisdictions are not uniform, the rule that should be adopted by the court is an attorney retained by a client for litigation. Though undoubtedly an agent for the client in the litigation, nonetheless stands in the capacity of a non-servant agent, independent contractor, and therefore the client is generally not vicariously liable for the lawyer's misconduct, absent exceptions to the general rule that are not present here. Although the authorities are not unanimous, most other jurisdictions have considered the issue that concluded the attorneys retaining litigation act as independent contractors, and those jurisdictions have accordingly imposed limits on clients' liability for tortious acts by their attorneys. There are sound reasons why multiple jurisdictions have concluded that vicarious liability should have a limited application in the context of the attorney-client relationship. Lawyers are legal professionals, typically are not subject to their client's control with respect to the manner in which they provide their services. If clients cannot control the details of the attorney's work, it makes little sense that clients should nonetheless be held accountable for their attorney's tortious actions. Attorneys generally not subject to their client's actual control. More citations. Although a lawyer is subject to the client's direction with respect to the goal of the representation, it is the lawyer who has a wide discretion as to that means by which the goals are achieved. In every American jurisdiction, including Virginia, a lawyer is required to exercise independent professional judgment and is subject to independent professional and ethical obligations. Further, a lawyer is prohibited from advancing frivolous arguments on behalf of the clients, VRPC Rule 3.1, and a lawyer has a duty of candor to the court and is permitted to refuse to present evidence on behalf of a client the lawyer reasonably believes is false. A lawyer is, in sum, required to exercise professional expertise beyond that of a typical client. There are accordingly substantial limitations on the client's ability to control the activities of the lawyer. In any case, a typical client who generally lacks legal expertise cannot monitor the conduct of a lawyer for wrongful activity. As a client's agent, the lawyer's conduct may be binding on the client with respect to the position taken in litigation or in a business transaction, but to hold the client liable for attorney's intentional tort goes to a step too far and is fundamentally inconsistent with the logic behind independent contractor principles of limited liability. Here, the evidence established that Mr. Waldman was retained by Mr. Depp to act as his attorney, and that he acted in the capacity in several litigation matters, including the initial stage of Mr. Depp's litigation against Ms. Heard. Other facts that underline Mr. Waldman's role as independent contractor only are that he is the managing partner of his own firm, has clients other than Mr. Depp, and offers legal services to his clients. Ms. Heard presented no evidence that Mr. Depp was personally involved in directing or making the Waldman statements. In fact, the uncontroverted evidence was that Mr. Depp never even saw the Waldman statements prior to seeing Ms. Heard's counterclaim in August 2020. Accordingly, the premise of Ms. Heard's counterclaim is that Mr. Depp is liable for the Waldman statements for no other reason than Mr. Waldman is his attorney. No one appears to dispute that Mr. Waldman did not act in a capacity for Mr. Depp other than his attorney. As Mr. Depp's attorney, Waldman should be considered an independent contractor whose tortious activity, if not, cannot be imputed to Mr. Depp without some proof of direction or control. The hilarious part was how many times she repeated over and over again. The witness had no idea what she was talking about and even laughed at her. Wait, what were we talking about? Ms. Heard presented no evidence of Mr. Waldman's actual malice. Even if the court were to conclude that Mr. Depp could be held liable for Mr. Waldman's allegedly tortious conduct, the court nonetheless erred in denying Mr. Depp's motion for summary judgment and motion to strike because Ms. Heard failed to present evidence to establish one of the required elements of defamation. Specifically, Ms. Heard failed to present evidence that Mr. Waldman acted with actual malice when he made the April 27th statement. As noted above, Ms. Heard chose to pursue a theory of vicarious liability against Mr. Depp at trial. She did not ask the jury to find that Mr. Depp was directly involved in making the Waldman statements, nor did she present any evidence that would permit the conclusion. Vicarious liability is liability for the tort of another person. A vicarious claim, therefore, cannot proceed against an employer or principal absent of showing that the agent or employee committed a tort. Let me take a break real quick. Holy shit. No. I don't think Ninja Turtles. I don't think Master... What's his name again? What was the name of the rat? I don't think they want her in the sewers with them. Let them live their life. Splinter! Yes! Master Splinter. Amica hair products. I do too, Katrina. I use Amica hair products. That's why when Elaine said Amica, I was like, Amica hair products? They make bruise cream too? The heck? I didn't know that. Because the principal cannot be vicariously liable for his agent's tort unless the agent committed all elements of a tort in the first place, Mr. Depp cannot be vicariously liable for Mr. Waldman's alleged tort against Ms. Heard carried her burden of proving that Mr. Waldman committed every element of defamation. 1. Publication. 2. An actionable statement with 3. A requisite intent. With respect to the requisite intent, a plaintiff who is a public figure, such as Ms. Heard, must prove that a false and defamatory statement was made with actual malice. i.e. subjective knowledge that it was false or with reckless disregard, or whether or not it was false or not. In order to establish actual malice, a plaintiff must demonstrate by clear and convincing evidence that the defendant realized that his statements were false and that he subjectively entertained serious doubt as to the truth of the statement. Importantly, actual malice is a subjective standard that examines the actual beliefs of a person publishing defamatory statement at issue. Consequently, actual malice is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. Rather, there must be sufficient evidence to permit the conclusion the defendant in fact entertained serious doubt as to the truth of publication. Scroll down a little bit more. Thus, for instance, a mere failure to reasonably investigate the truth of one's word is not enough to establish actual malice because it does not establish subjective knowledge of falsity. Indeed, in the context of actual malice inquiry, a duty to investigate the accuracy of one's statements does not arise until the publisher of those statements has a high degree of subjective awareness in their probable falsity. Thus, to succeed on the defamation claim against Mr. Depp, Ms. Heard was required to establish by clear and convincing evidence that when Mr. Waldman made the Waldman statements, he either knew that they were false or that he subjectively had a high degree of awareness that they were probably false. Clear and convincing evidence is the measured degree of proof which will produce in the mind of the triers of fact a firm belief or conviction as to the allegations sought to be established. On review, appellate courts must exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. Steve! Stevie? Steve, the neighbors start barking. Why are you barking now? And my alert should pop up now! Yes, okay, I don't know what YouTubers use for their alerts, but I gotta get on it because my alerts are a little bit meh. Yes, this is what I was talking about. Thank you. Senku. So this came out after the trial was over. So it says from Adam Waldman to Camille, Benchu, and Christian States. I have interviewed Drew. Here are the key points from that call. Yeah, so Josh Drew must have came forward with like these claims, and afterwards he probably retracted it. 1, Rocky and Amber's sworn stories that she was in summoned by 8:07 p.m. text to come help her with the berserk Johnny was a lie. Rocky was hiding in Penthouse 5 all along, almost certainly in the coat closet by the front door, which explains both the security guard's testimony that she never came past them and was already in the apartment when they entered, and that when they entered, and Johnny's that Rocky just came out of nowhere past the right shoulder to go stand with Amber. Super important fact, and I hope you will repeat it. This will make the whole thing a setup and discredits both their testimony. 2, Amber was sleeping with Musk all week after the 21st, obviously not on the Franco night, the 22nd. 3, Amber and Musk were into some kinky things together. He didn't elaborate. 4, she did have marks on her at times. He even seemed to suggest that she had marks on the night of the 21st, although of course we know that is not true. Do we know if he ever gave her a declaration to Amber? I bet he did back then. 5, there was a long gap between Johnny's departure and calling the cops, perhaps an hour or more. He couldn't be precise. During that time, they all sat together in Penthouse 3 on the phone with Samantha Spector, her divorce lawyer, who was guiding them to writing it all down to get their story straight before calling the cops. I don't know if you guys saw, but there were text messages between Johnny Depp and Amber before he came to the penthouse. And, I don't know. It's just kind of sickening. Like, imagine someone plotting all this against someone just so they can look good when they split. But, meanwhile, she was, texting him, all, I don't know, not lovey-dovey, but, sort of lovey-dovey. I don't know. I don't have the text messages with me right now, but if anyone has a link to that, send me it, please. But you could see their communications before he showed up at the penthouse. This was a planned thing. It's not like Johnny Depp just showed up out of nowhere at the penthouse, start rampaging and telling her friends to get the fuck out. He came to meet her and just talk a little bit, and he came to get his stuff and just get the fuck out, right? But I don't know. It's fucking weird. No one is bothered about finding out her source of money. She's got no money to pay Johnny, but she's got money to pay for the bond. Yeah, especially sick considering his mom had just died. I know. It's so, I don't know. It's just, there's just so many layers of fuck-uppery, and it's sad. Yeah, it's just really fucking sad. And I think that's why a lot of people, when they start looking into the trial, the UK stuff, and even finding out things from this trial in the US, I don't know. It was just, I think a lot of people just really got sucked into it because of how much crazy shit this man had to endure. It's fucking wild. Very crazy. Ms. Heard presented no evidence, much less clear and convincing evidence that Mr. Waldman made the 27th statement with actual malice. Indeed, with respect to the 27th Waldman statement, Ms. Heard presented no evidence regarding whether Mr. Waldman believed his statements to be true or false. All evidence adduced at trial pertaining to Mr. Waldman's state of mind when he made the Waldman statements shows that Mr. Waldman believed those statements were true. Mr. Waldman testified at length, for example, about why he believed that Ms. Heard's allegation of abuse were false, citing testimony from multiple witnesses that contradicted Ms. Heard's account of events, including discrepancies in Ms. Heard's own story. In fact, Mr. Waldman testified that he had filed a claim with LAPD against Ms. Heard for perjury due to her claims that Mr. Depp ate her, and that he presented them with information that he believed to establish her perjury. Do we have a copy of this claim that he filed? Did he really file the claim? I thought he showed up and was about to file the claim, but he didn't. Or do we actually have a police report on it? Fuck, I don't remember. Ugh, there's so many things going on. Ms. Heard presented no evidence that would permit the jury to find clear and convincing evidence, and Mr. Waldman subjectively knew that his statements were actually or probably false. C. In context, the Waldman statements are not actionable. Even if the court believed Mr. Depp could not be liable for Mr. Waldman's statements, Ms. Heard's counterclaim for defamation is still fundamentally defective because, read in context, the April 27 Waldman statement is not an actual statement of fact. The trial court thus erred in granting Mr. Depp's motion for summary judgment and motion to strike the evidence. Pure expressions of opinion, not amounting to fighting words, cannot form the basis of actions for defamation. The First Amendment to the Federal Constitution, Article 1, Section 12 of the Constitution of Virginia protect the right of the people to teach, preach, write, and speech in such opinion, however ill-founded, without inhibition by actions for libel and slander. Conversely, there is no constitutional value in false statements of facts. Thus, in an action of defamation, the court must resolve as a threshold matter whether an alleged defamatory statement is one of the fact or of opinion. A statement of fact is one of provably false factual connotation, which can be reasonably be interpreted as an actual facts about a person. However, even a provably false statement is not actionable if it's plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, surmise, rather than claiming to be in possession of objectively verifiable facts. Importantly, in assessing whether allegedly defamatory words or fact or opinion, a court must examine them in context, with the aim being to interpret them as the other people would understand them according to the sense in which they appear to have been used in the totality of the circumstances. Oh yeah, I could totally see that, Rain. Definitely. Like, just trying to, like, shove it in his face, you know? Or maybe even try to get him jealous and, like, try to get him to, like, want her back or something like that. Importantly, in assessing whether allegedly defamatory words are in fact... Wait, did I read this? I think I read this. Did I read this? Shit. I forgot. I need to scroll down when I read something. I think I read this. Thus, in considering whether the statement's audience would understand it as a statement of fact, opinion, court considers such factors as the form in which the allegatory defamatory statements were uttered, or whether an audience familiar with the form would expect to hear an opinion. Court also considers the degree to which a statement's audience is familiar with the underlying facts and therefore able to assess the defamatory statements for themselves. In addition, courts consider whether the statements remain in the context of debate or controversy, because statements made in the heat of a debate are more likely to be understood by the audience as expressions of opinion. Courts also consider the identity of the speaker and whether the speaker's biases are known or disclosed to the audience. The most unsophisticated recipient of such a claim made by one competitor against another could only regard as a relative statement of opinion grounded upon the speaker's obvious bias. Further, courts can consider whether the speaker claims to have personal knowledge or is merely drawing inferences about events he does not claim to have witnesses. The 27 Adam Waldman statements are presented to the jury reads as follow. We read that already. When read in isolation, it could arguably be interpreted as a factual statement sufficient to state a claim for defamation. When viewed in context, however, it is not actionable opinion. Importantly, the April 27 Waldman statement is presented as a statement by a lawyer in the context of litigation and necessarily represents only one side of a heated debate. Further, it was made to the reporter who presented quotes from both sides of the debate and was necessarily where the facts were hotly disputed. Indeed, April 27 article quotes Ms. Heard's attorney referring to Mr. Waldman's statements as fantasies. Mr. Waldman never claims personal knowledge of what happened on May 21st at Mr. Depp's and Ms. Heard's shared penthouses, and no one disputes this. Rather, it is clear from the April 27 article that Mr. Waldman was speaking as a legal advocate and offering his own interpretation of disputed evidence. The April 27 Waldman statement is thus most reasonably understood as an attorney's interpretation of a conflicting allegations and evidence as a he said, she said dispute, and as such cannot be defamatory. Oof. Okay, I think we're almost there. In context, it is clear that each of the Waldman statements, including April 27 Waldman statement, reflects a subjective view, interpretation, a theory, conjecture, or surmise, so as not to be actionable opinion, to be non-actionable opinion. Mr. Waldman indisputably had no personal knowledge of what happened at the ECB. Oh, by the way, I used to live near the ECB. It's actually a fucking gorgeous building, especially at night. I took some pictures, but I forgot to post it on my my YouTube channel thing. Had to get some pizza. The place is short staffed. Got a free pizza out of this and the tip refunded. Oh, nice. What kind of pizza did you get? Order DoorDash. They drop it in the wrong house. They stole your latte. Rip. I don't know. I don't do food delivery services. It takes too long. Sometimes it gets delivered to the wrong place. Sometimes it takes forever. And like for me, I'm just like, I'm hungry. I want it now. And I also don't like the fees that they add on there. Mr. Walden was merely drawing inferences, speculating based on the evidence available to him what must have happened on May 21st. This reason, good faith interpretation of evidence cannot be defamatory. The trial court accordingly erred in denying Mr. Depp's motion for summary judgment and motion to strike. 2. The trial court erred in denying Mr. Depp's proposed jury instruction number 22, 23, and 24. We're almost done, guys. Just a couple more pages. Standard of review. Jury instructions are reviewed under the A of discretion standard. Gaines v. Commonwealth. In reviewing the trial court's decision to refuse jury instructions, evidence is viewed in the light most favorable to the proponents of the instructions. Whether the content of the instruction is an accurate statement, I'm going to skip all this. Discussion. Evidence was presented from which a jury could have found that Mr. Waldman was independent contractor. At trial, Mr. Depp proposed jury instruction numbers 22, 23, and 24. I guess I should read it, actually. Okay. So they proposed to have this included in the jury instruction. Number 22 is independent contractor is a person who's engaged in produce a specific result, but who is not subject to the control of the employer and person was the way he brings about the result. If you find that Mr. Waldman's acting on Mr. Depp's behalf was not subject to Mr. Depp's control as to the matter, method, or by means by Mr. Waldman's work, you must find that Mr. Waldman's an independent contractor. 23. An outside lawyer retained by a client in connection with litigation is an independent contractor. 24. A person who hires an independent contractor is not liable for the independent contractor's actions. If you find Mr. Waldman's an independent contractor, Mr. Depp instead of employee, you may not find Mr. Depp liable for Mr. Waldman's conduct. The court denied these instructions. Mr. Depp incorporates by this reference and will not repeat at length arguments set forth above regarding Mr. Waldman's status as an independent contractor. In sum, since evidence supports a finding that Mr. Waldman was an independent contractor, his allegedly tortious conduct cannot be imputed to Mr. Depp absent evidence of additional involvement by Mr. Depp in making a defamatory statement which was not presented at trial. The evidence at trial established that Mr. Waldman represented Mr. Depp solely as an attorney in various litigation matters, but in no other capacity. As such, the court should adopt the majority position of other jurisdictions that an attorney representing a client in litigation is an independent contractor. Even if the court declines to adopt a per se rule, evidence was presented from which the jury could reasonably have found that Mr. Waldman, was an independent contractor not subject to the client's control in the details of work. For instance, Mr. Waldman testified that he is the owner, managing member of his law firm. So a lot of this is like a lot of repeats because they just want to make sure they like drill everything in and yeah. And that he offers legal services to clients and cover all the bases. And that Mr. Depp is not only his clients. He offers legal services to clients and that Mr. Depp is not his only client. Accordingly, the trial court erred in rejecting jury instruction number 22, 23, 24. 3. The trial court erred in excluding the full articles containing the Waldman statements. The trial court decision to admit or exclude evidence is reviewed under the A of discretion standard. So this talks about how unredacted articles provide necessary context. I think I'm going to skip this part because we kind of already covered it. Conclusion. This court should reverse the judgment of Ms. Heard's counterclaim as the April 27 Waldman statement, but should otherwise affirm the judgment in Mr. Depp's favor. Wouldn't it be funny if they reverse this judgment? It would be so funny if they reversed this judgment and they denied Amber Heard's appeal. Because like Camille Vasquez says, they wouldn't have appealed if Amber's side didn't appeal. No, they wouldn't have appealed if Amber's side didn't appeal as well. Okay, respectfully submitted, Mr. Benjamin Jew. All right, guys, we made it. Yay, we made it. So this is just an article covering it, and I'm not going to read it. But anyways.